It's 4 o'clock in Johannesburg. Good afternoon, ladies and gentlemen. My name is Mbongiseni Buthelezi, and thank you for joining us this afternoon. People will be joining over the next few minutes, this event. So in the meantime, before we start, we'll just give a few minutes to people to join. I'm going to ask you to just get those fingers exercising by telling us in the Q&A where you are joining us from today. We'll give it the next 2-3 minutes, and then we will start our discussion. So in the Q&A, if you can just please tell us where in South Africa, where in the world are you joining us from? Once again, as people join the meeting, thank you for joining us. I'm asking that while we wait for a few more people to join us over the next few minutes, if you can please just pop into the Q&A, where in the country, where in the world are you joining us from? Alex is joining us from Toronto, Canada. Somebody joining from Nelspruit. We have somebody in Durban joining us, Site, Anonymous in Pretoria, Zenande in Cape Town. Anonymous, Etegwini Municipality, Durban. Somebody's joining us from Sweden. This is wonderful. Please keep those comments coming in the Q&A, where tell us where you're joining us from. We'll be starting in a few minutes. We're just waiting for a few more attendees to join. Joburg, Peter Didias, hello, good afternoon. Aisha joining from a chilly Cape Town. Join the club. We are in a very chilly Joburg. Yeah, that's where I'm joining you from. Romabina, Fezega, Neto, Ochistad, Limpopo. Derek is joining us from LA, California, in the USA. We have Christy Gurley joining us from Cape Town on behalf of the Women's Legal Center. Kathy Powell, UCT Law Faculty. Thank you all for joining us. We're kicking off shortly. Okay, I think we can get started. Once again, good afternoon, ladies and gentlemen, and thank you very much for joining us this afternoon. My name is Mbongiseni Buthelezi. I'm joining you from a frosty Johannesburg. This event is hosted by the Land and Accountability Research Center at the University of Cape Town. And I'll be introducing the speakers in a moment. Just a quick note to say we have had at short notice a change in the program. Unfortunately, for those of you who are following your TV screens at the moment, you'll know that Tembeka Ngcukaitobi is arguing a case in the High Court in Pietermaritzburg as we speak. Unfortunately, therefore, Tembeka Ngcukaitobi will not be able to join us. But our other two speakers, Aninka Claassens and Luwaya, are here with us and we'll be hearing from them. The event is it's been a month since the High Court in Pietermaritzburg issued a judgment in a case on the Ingonyama Trust. The case, as all of you will know, was many years in the making, and we'll hear about that this afternoon. The applicants in the case, among them, were the Council for the Advancement of the South African Constitution, the Royal Women's Movement, and various individuals who live on land that is held by the Ingonyama Trust. It concerned, I think centrally, the question we're going to be focusing on today. What are the implications of this judgment on the tenure rights of people who live under the Ingonyama Trust or on land held by the Ingonyama Trust, held in trust, I should say, by the Ingonyama Trust in KwaZulu-Natal. Our speakers this afternoon, as I've said, will be Dr. Aninka Claassens and Ms. Nolundi Luwaya, who I will introduce in turn just before they speak. There are major implications, of course, of this case. There are implications about accountability. There are legal implications, but also there are political implications that a lot of us have been asking ourselves questions about. Today, as I've said, we're focusing on the tenure security of rural South Africans, especially people in KwaZulu-Natal. Some 12 years ago, the Ingonyama Trust started converting the rights of or customary ownership rights of people living on land in KwaZulu-Natal to leasehold on land that is held by the Ingonyama Trust. This is what that was challenged in this matter, and we are now going to invite our first speaker, Aninka Claassens, to tell us what we're inviting her to talk about is really problematizing this notion of communal land, firstly, and secondly, then thinking with us through what customary ownership of residential and arable land implies for the communal land tenure bill and also current law in South Africa that favors traditional leaders. Aninka Claassens is the former director of the Land and Accountability Research Center. She was, and she will not like me saying this, my boss when I worked at that center. She doesn't like being called a boss. And she's currently a chief researcher at LARC. She did research for the legal challenge against the Communal Land Rights Bill, which was struck down by the Court in 2010. She has co-edited, among others, a book titled Land, Power and Custom, about some of the controversies generated by the Communal Land Act with Ben Cousins, as well as Marriage, Land and Customs, which she co-edited with Dee Smythe, about law and social change in South Africa. Aninka is a long-time activist in the land space. She's been an expert witness in a number of cases related to land rights, customary law, and accountability in the Court and various other high courts. In 2016 and 2017, she also chaired the land working group of the Motlanthe High-Level Panel, investigating the impact of post-apartheid laws on poverty, inequality, land reform, and social cohesion in South Africa. And finally, I should also add, Aninka holds a PhD in development studies from Roskilde University in Denmark. So Aninka, over to you. Thank you. Unmute yourself, Aninka.
Okay, thank you. Thank you, Mbongiseni, and welcome to everyone who's attending this webinar. My topic was really to focus on the implications of the judgment for this very common construct in South Africa of communal land. But before I begin, I just want to provide a few headlines about what the judgment found, because Tembeka can't be with us this afternoon. And basically what the judgment found is that people who had been issued with residential leases in respect of land that they occupied in terms of customary law are now entitled to have those leases cancelled and to get all the rent that they had paid back from the Ingonyama Trust. The judgment found that the trust and the trust board had breached the Constitution, had breached the Interim Protection of Informal Land Rights Act, and very seriously had breached customary law and the Ingonyama Trust Act in forcing people to take out residential leases when all that they were looking for were secure records of their pre-existing customary land rights. The judgment also makes a very strong finding against the Ministry of Agriculture, Rural Development and Land, and in that it finds the minister in breach of her duty to enforce constitutionally protected property rights, and it goes so far as to order the minister to provide people with permission to occupy certificates, which is the only form of recorded rights that is available because of government's failure to introduce any other form of protected land rights since 1994. And beyond that, it orders the minister to report on her progress with issuing these PTO certificates every 3 months to the court until such time as they agree that there's no longer any need for this reporting. So it is a very far-reaching, comprehensive judgment that finds both the trust board, and the minister having acted in contravention of the Constitution and undermining the basic property rights that people have in terms of customary law and a whole set of statute laws. So what are the implications for the judgment beyond the people in KwaZulu-Natal who are going to be able to get those leases cancelled and their rent returned to them? And really the judgment has extremely far-reaching implications for all South Africans living in the former homelands. And it also has far-reaching implications for the meaning of the term custodianship. And this term custodianship, as we know, is now one that's used regularly in relation to the debate about the amendment of Section 25. And the judgment throws quite a lot of revealing light on what custodianship means and what it doesn't mean. And the facts of the judgment show the alarming way in which government has failed to enforce property rights which have been systematically abused by a custodian, despite being fully aware of those abuses and despite being fully aware of those abuses and being put on terms by the Legal Resources Centre to address them, that government nevertheless failed to protect those rights. And so this really does sound a warning that if government could ignore these rights since 2007, when these residential leases were first issued for vulnerable people in KwaZulu-Natal, how safe is anyone's property rights if we got custodianship applied more fully within South Africa? But to come back to this idea of communal land, this idea that the former homelands are communal land is often reiterated by government. We've heard the president talk about 3 categories of land being state land, private land, and then communal land, as though it is somehow neither private nor state owned. And we've basically heard of an elision between this construct of communal land and the powers of traditional leaders as custodians, in other words, as owners of communal land. And what the judgment does is it fundamentally challenges the idea that the land in the former homelands is communal land by pointing out that all land that is occupied and used, so all residential and arable land that has been allotted to people in terms of customary law, is their property in full ownership, and it cannot be regarded as communal. The only land that can be regarded as communal is land such as grazing land or forest land, and even that, the judgment makes clear, is under the control of the specific families and people who use that land. So, and as I've said, this not only has implications for the widespread widespread way in which customary land rights are elided with the idea of communal land, it also has far-reaching implications for the idea of a custodian as in control of either customary land rights or communal land. So what the judgment finds is that the trust is only the nominal owner of the land, and it owns it on behalf of the customary rights holders who are the true owners. Now, the idea that customary law provides for ownership is not new. That is a precedent established by the Constitutional Court in 2003 in the Richtersveld and Alex Court judgment, in which the court found that customary rights are not akin to ownership, as the appeal court had found. It found that they are ownership. However, Alex Court, while it talked about communal ownership, while it talked about ownership by communities, that the communities are the full owners, it didn't break down the rights that individuals within communities have. And that's really where this judgment breaks new ground. And it talks about how land that's been allotted to individuals cannot be regarded as communal. So, for example, at paragraph 136, the judgment says, under customary law, each member of each class or community is entitled to an allotment through procedures under customary law. Once a portion of land has been allocated to a particular individual as residential or arable land, it is automatically taken out of the realm of communal ownership. And that's very important for us to understand. It is demarcated and has fixed boundaries. The ownership thereof descends from generation to generation of such particular owner or family. However, unallotted or uncommon land is communally owned by all members of a particular community under the administration of an Induna and Inkosi. However, both communal and individually owned land is defended by all members of the community concerned against attack or interference by others. And at other points, the judgment states how strong the specific rights of users of grazing land are. And it talks about the nature, the strength of the rights held to allotted land. And it says the individual, and this is at paragraph 96, the individual's holding of a portion of the land allotted to him or her is sacrosanct in that it is inviolable and passes from generation to generation. It is inheritable. It becomes the property of the individual's family. Nothing can be done with it without the involvement and consent of such individual or his or her family members. The owner of residential or arable land acquires an exclusive right to its use. So in other words, this is privately owned land. And to talk about it as if it were a completely different category of land from other privately owned land is really to fundamentally discriminate against customary law as a source of law and as a source of property rights. So what are the implications of these findings about the nature of the strength of the ownership of allocated land? The finding is that most so-called communal land is already owned by families who have inherited it over generations. And it is not in the power of the state to give that land or to give title of that land to anybody else, because it would be expropriating their underlying ownership of the land. So it's not in the state's power to transfer title of that land to traditional leaders or any other type of custodian. if the state wanted to transfer title of that land to anybody else, it would first have to expropriate these rights, which, as the judgment shows, building on Alex Core, are ownership rights. And this was also reiterated by the Tongwani judgment, which struck down the Communal Land Rights Act in 2010, when the Tongwani judgment found that this Communal Land Rights Act would actually interfere in a world where there are already pre-existing systems of rights and ownership derived from customary law. So what has happened is the state has ignored these judgments and really reiterated this idea of communal land as a kind of tabula rasa, where title vests in the state and the state has the power to transfer that title to traditional leaders, completely ignoring judgments which find that the people living on that land are the underlying owners. What this means is that the Communal Land Tenure Bill, which is a long-awaited piece of legislation that the department promised would be ready by the end of April this year, is dead in the water. Because that bill proposes the transfer of the outer boundaries of communal land to traditional leaders. Initially, it was to traditional councils, but we understand that there's been a political shift away from vesting it even in traditional communities and rather vesting it in traditional leaders. Now, Section 25(6) of the Constitution protects land rights that are vulnerable because of past racial discrimination. And Section 25(9) requires the state to enact a law to give effect to those rights. And so the Communal Land Tenure Bill is there to fulfill a lacuna, because since the Communal Land Rights Act was struck down, the state has done nothing to secure the land rights of people living in the former homeland areas, which are by definition vulnerable due to centuries of discrimination. Now, the implications of people's rights being recognized as ownership also gives them rights of control over their land. Decision-making is an incident of ownership. And what the judgment makes clear is that part of ownership is the person having control and decision-making authority, which cannot then be vested in any other structure, such as a traditional leader. So it says such rights, referring to customary rights to allotted land, entitle the owner to occupy and use the land, to dispose of such land to another person, to erect a building or let it, and to transfer it to another person, including bequeathing it to his or her children. Tenure of residential land is perpetual, transferable, and inheritable. And it follows, the judgment follows the structure of the Interim Protection of Informal Land Rights Act of, suddenly forgotten the date, I know this off by heart, 1996, which basically differentiates between rights to occupy, rights to use, and rights to access land. And it says that where residential and arable land is concerned, if there's going to be any change to those rights, the holder must agree. The approval of the community is only relevant when it comes to shared rights, such as grazing rights. So the judgment states in Section 131, in terms of IPILRA, which is this Interim Protection of Informal Land Rights Act, any deprivation of informal rights to land must be with the rights holder's consent. Or, if the land is held on a communal basis, it must be in accordance with the community's custom or usage, subject to the payment of compensation as approved by the majority of the community members present at a specially convened meeting where due process is followed. Now, this is a crucial clarification because we've had decades of disputed mining projects on communal land, well, in the former homelands, where basically traditional leaders have signed deals with very little input from the community's members whose customary land rights are at issue. Now, we had a major breakthrough in 2018 with the Maledu judgment of the Constitutional Court. And that judgment found that the right to mine cannot trump the right to tenure security in the Constitution. And it found that this Interim Protection of Informal Land Rights Act and its consent requirements must be upheld before a mining right could be issued. But the Maledu judgment of the Constitutional Court, quite like the Richtersveld and Alex Court judgment, while it upheld the rights of communities, didn't really clarify what that means for individuals within communities. It didn't break down this requirement of consent in relation to how it would work in practice for people who've got houses on the affected land, people who've got fields, people who've got cattle grazing on the affected land. And this judgment goes further than the Maledu judgment in that it embeds this ownership firmly in customary law. The Maledu judgment also embedded the rights in customary law, but it focused much more on the Interim Protection of Informal Land Rights Act and its status as a law that was required by Section 25(6) of the Constitution. Whereas this judgment really, it refers to a whole series of statutes as providing people with strong rights, but it really embeds these rights as deriving from customary law. And it clarifies that the consent requirements are completely different for a person or a family whose house would be affected. Then you must get the consent of that family, and that family must be compensated. Similarly, if a person's fields are going to be affected, that family must agree. And it's only if it's a common area, like the grazing area, that you would convene a group of people and you would get the consent of the majority of those people. Now, this is very, very different from the approach adopted by Minister Gwede Mantashe in respect of the Tolobeni judgment about consent for mining, also a 2018 judgment. And after that judgment, he wanted to actually go into the area and conduct some kind of survey as to in which people would vote whether they consented or not. But that was without identifying which land and which rights would be affected. Now, if you don't go in and identify exactly what land is affected, who's got what houses on that land, who's got what fields, then you cannot begin to say that any other grouping of people than those directly affected have got the right to consent. And what we have here is a serious problem in that in 2019, after these two groundbreaking judgments, government enacted a law called the Traditional and Khoisan Leadership Act. And that law purports to give traditional leaders the right to enter into investments on behalf of rural communities, but rural communities that were formerly called tribes. So they are given a right to represent traditional communities, previously defined as tribes, in respect of making deals with mining houses and other external investors, whereas this judgment and the previous Constitutional Court judgments talk about affected rights holders. The people to be consulted and to provide consent need to be identified according to the degree to which their land rights are at issue, not according to some superimposed boundary of tribal identity. And obviously the boundaries of the group will change significantly depending on which definition you use, because it will often be many fewer people directly affected by the mining, and it's those people who should be making the decisions not people from 3 villages away who have been promised jobs. You know, what happened with the Traditional Khoisan Leadership Act is that as a result of the Maledu judgment, there was a final concession that there must be some degree of consultation, but that consultation is with the tribal unit rather than with the people who are directly affected. Now, the judgment is made in very resounding terms. It finds not just that the board and the trust breached the Constitution, they breached the Ingonyama Trust Act, they breached customary law, they breached the KwaZulu Land Affairs Act, they breached the PTO regulations. It also finds that that the minister breached her duties. So what it says in respect of the board at paragraph 102 is that the conduct of the trust and the board, as outlined above, amounts to an arbitrary deprivation of the beneficiaries and residents' PTO rights, customary law rights, and informal rights to or interests in the trust-held land. Such deprivation is not only in violation of the provisions of the Trust Act, but also of IPILRA and of the Constitution. Now, having had this judgment, are we going to see a change? Is this going to be the end of the communal land tenure bill? Is it going to be the end of the very confused construct of custodianship? And the answer, unfortunately, is no. Because despite this question of underlying ownership vesting in individuals through customary law being crystal clear in law, ever since the 1980s when there was a textbook by Alistair Kerr, it was reinforced by the 1991 upgrading of Land Rights Act, it was reinforced by the Interim Protection of Informal Land Rights Act of 1996, it was reinforced by the 1997 White Paper on Land Policy, by the 2003 Alex Gore-Richtersveld judgment, by the 2010 Tongwane judgment, by the 2018 Maledu judgment, and now by this judgment. What you've had is government absolutely intent on a program of transferring title of land in the former homelands from itself as the nominal owner, because most of that land is vested in the state. If you go and look at the title deeds, it'll say Government of the Republic of South Africa. They are intent on transferring that to traditional leaders or traditional councils. As we saw with the Communal Land Rights Act of 2004, which was struck down by the Constitutional Court in 2010. But despite it being struck down, senior politicians have continued to treat traditional leaders as though they are the de facto owners of communal land and not the people living on that land. So you've had the 2019 Traditional Khoisan Leadership Act, and then the announcement earlier this year that the Communal Land Tenure Bill is about to be brought before Parliament. So what we've got is property rights that are clear in law, but politics superseding those property rights. And the judgment explains this beautifully. It says at paragraph 25, it is unfortunate and saddening to note that Mr. Ngwenya, who's the chair of the Ingonyama Trust Board, regards this application as an attack or affront on the institution of Ubukosi under the democratic order, rather than as an exercise of the applicant's right to seek protection of constitutional rights and protecting their property rights. So he's saying Ngwenya couched their objection to their dispossession as an attack on Ubukosi, whereas it is an attempt to defend their constitutional rights. He says, the judgment says, any evidence in support of his assertion that the applicant's intention is to strip the Zulu nation of its identity is contrary to his assertion. Okay, sorry, I've got mixed up here. So he says, Ngwenya says the applicant's intention is to strip the Zulu nation of its identity. Yet the papers reveal that the applicants seek to protect rights and interests in trust-held land through judicial redress and to address conduct inconsistent with the notion of fairness and justice which inform public policy. It says the applicant's case is not about the role and constitutional status of the sole trustee of the trust, then King Zwelithini Bheki, and the constitutionality of the Trust Act, but it concerns the unlawful and systematic deprivation of property rights and security of tenure of the residents of land nominally owned by the trust. So what we've had is leases, residential leases being issued to people who are the underlying owners since 2007. And as the judgment says, the minister, previous ministers of land affairs were fully aware of this because they got reports from the Ingonyama Trust every year, annual reports to the minister and to Parliament every year. And yet ministers turned a blind eye to this blatantly unconstitutional program. Okay, thanks. I see I must wrap up. And they make very, very strong findings against the minister and go so far as to order the minister to report to them on her progress with issuing PTOs. And the problem is, this is the third structural interdict against the Minister of Land Affairs attempting to enforce vulnerable land rights. We've got a structural interdict against her because of the failure to enforce the rights of labour tenants. There's a structural interdict against her because of the failure to expedite the restitution process for people who laid claims before 1998. Now there is a third structural interdict saying that the minister must protect the rights of vulnerable people. Now, how do you protect the rights of vulnerable people when there's a lack of political will and a lack of capacity? Because people whose rights are not recorded are inherently vulnerable to potential abuse, and they're also locked out of the formal economy. So for this problem to be solved, it requires more than the trust desisting from exploiting them, or traditional leaders desisting from entering into mining leases. It requires a proactive process by the state to register and record these informal land rights so that their legal status, their reconfirmed legal status as ownership, is something that people are able to defend. And until we have political will from the government that it wants to actually invest in vulnerable rights of rural people, that enormous practical job is not going to be done. And what we've all got to note is that any move towards custodianship puts people in the exact position that the people in the Ingonyama Trust have been in, and that their vulnerability has been well exposed by the Motlanthe High-Level Panel, by the Presidential Advisory Committee, and despite all of that, the Ministry of Land refused to come to the aid of rural people. Instead, it intervened in this litigation on the side of the trust. So God help us all if we find that we are all the beneficiaries of custodians of our land, because our government is not going to do so.
Thank you very much, Aninka, for that very illuminating analysis. Without further ado, we're going to move on to our second speaker, Madundi Luwaya. Madundi Luwaya is the current director of LARC. LARC, just to say, is the research center in the Department of Public Law at the University of Cape Town. The center is concerned with power relations and the impact of national laws, as well as policy dealing with customary law in framing the balance of patriarchal and autocratic power within which rural communities struggle for democratic change in their former homelands, as you've heard Aninka describe. So Madundi dealing with particularly the implications of the judgment for different leaseholders in the province of KwaZulu-Natal. Over to you. Thank you.
Thanks very much, Mbongiseni. So as you've outlined, I'm going to speak specifically to the implications of the judgment in relation to the various forms of leases that exist in the KwaZulu-Natal context. And part of what I'm hoping to do here is just provide some guidance around what the actual judgment means for these various leases, to try and just assist people with having a clearer understanding as to how exactly the various leases are impacted by the judgment. So to begin with, I'm just going to sort of disaggregate, speak a little bit about what these types of leases are. Obviously, there is the residential lease, which is the main issue and the lease that was dealt with and most impacted directly by the judgment. And these are leases over residential, arable and grazing land, and are frequently, as the judgment lays out, held by individuals or families, and are an exercise of a right of occupation, access, and ownership. There are also then leases that are conducted between members of the community and the Ingonyama Trust, and members of the community who are hoping to hold a small business or establish a small business. So these are leases for people who have businesses like various types of shops, petrol stations, and sort of small commercial activities. The third type of lease then is a type of lease that I'm calling a social service. So this is a lease that's granted to a church, for example, or somebody who's wanting to establish a creche. And so again, these are members of the community who seek a lease or engage in this lease with the Ingonyama Trust for the purposes of a service that's beneficial to the community. And so these are the types of arrangements that have been converted into lease agreements by the Ingonyama Trust. The fourth type of lease, which I'll speak about on its own because it's slightly different, is what's termed the third-party lease. And I'll explain and expand on what the third-party lease is in a moment. So between the three types of leases that I've just spoken about, those that are residential, those that are about business, and those that are, as I said, related to social services. The judgment deals most directly with residential leases, so people who had PTOs that gave them residential rights to the residential site, but also to arable and grazing land, and whose PTOs were converted into a lease through the conversion program that was run by the Ingonyama Trust Board. What this means then is that those are the only types of leases that are automatically cancelled and that are automatically set up or allowed to be refunded based on the order that was given in this judgment. So it seems that there is some confusion around which of these leases people are automatically able to have cancelled, and for which people would have the money that's been paid, the rental that's been paid, refunded to them. So just to make clear that it's only actually the residential PTOs, which are now leases, that are automatically cancelled by the judgment and for which people can seek the refund. That said, the judgment does have implications for leases of the other kinds, right? So for leases where people had a PTO that allowed them to establish a business, or one for which they were establishing a creche or a church. For those particular types of leases, even though they are not automatically cancelled as a result of the judgment, there is, in my opinion, in our opinion, quite a strong argument that could be made for those leases to be considered within the broader parameters of this court order. And the reason for that is that the judgment speaks quite extensively, as Aninka pointed to, around this point of consent. And in the judgment, the kind of very clear articulation that's given, and part of the reason why the conversion program was deemed to be unlawful is that people were not actually able to consent in a meaningful way to supposedly converting their PTOs into a lease. And so the wording that the judgment uses of paragraphs 137, 138 is that the consent that's required for the deprivation of a right needs to be genuine and informed. And so the point that I'm making is that for those people for whom their PTOs that allowed them to run a small business or to have a creche were converted into a lease, they could make the argument that they did not give genuine and informed consent. They were not fully aware of the implications of that conversion, and so that the lease should not stand on those grounds. And given how strong a point Justice Madundi makes in the Ingonyama case, it would be possible then for this to be a basis on which people could ask for those leases to also be ruled unlawful, for them to be cancelled, and potentially for funds to be returned. So the kind of the point then is, even though there is no automatic impact on the business and social services leases, there certainly is the possibility of using the judgment as a foundation upon which to call for and ask for the cancellation of these leases based on not having given genuine and informed consent. And so for people who hold the business lease or a lease for a creche or a church, what can they do? How can they possibly seek some form of redress if they have been victims of the PTO conversion program that was run by the Ingonyama Trust? So what people can do is they could raise the issues that they have with these types of leases with the portfolio committee on land and rural development. Obviously, the judgment speaks again at length about how the portfolio committee did try and ask questions of the Ingonyama Trust in relation to the PTO conversion program. And certainly this would be an opportunity for holders of these business or church and clinic related leases to raise this and to make the point that they too should benefit from the outcome of the judgment. Alternatively, holders of a business lease or a lease related to social services could approach the department directly. In the weeks following the announcement or the release of the judgment, the minister made it clear that the department has the intention to honour the judgment, to do what they can, to abide by it and fulfil what's been called for. And so if the department really is committed to abiding by the judgment, this would be a really good avenue to ask them to kind of put their money where their mouths are. And so people who hold leases that are not automatically impacted by the judgment could approach the department and ask them to act in a way that would uphold their rights and in a way that would ensure that those who had their PTOs converted are able to seek some form of redress. And then, of course, the last option is potentially litigation. But this can take quite a long time. As we saw, the process of bringing this case to a final hearing took a number of years. And of course, litigation is also quite costly. And so even though it would be a last resort, it certainly would have quite a good basis and foundation upon which to build a case based on the outcome of this particular judgment. And so it would present an opportunity to develop and build on the precedent that is set by this case. But certainly I think the first two suggestions that I'm making around the portfolio committee and the department may well serve well as a first port of call. And so I come then to the point around third-party leases as the other category of lease for which the judgment has quite serious implications. Firstly, what is a third-party lease? A third-party lease is defined as a lease between the Ingonyama Trust Board and an external third party. So it's a lease between the trust and somebody who is not part of the community. And this is part of what sets it apart from the earlier business leases that I was referring to, because those are with community members, insiders, so to speak. So it's a lease between the Ingonyama and the Ingonyama Trust and an external third party. It's usually a lease for access to communal land for commercial purposes. So for many of these, as I'll speak to, there is a commercial incentive and an economic activity on the other end that propels the request for a lease. And it's a lease in which the Ingonyama Trust manages to obtain and source rental. And frequently, that happens at the expense of people who may well be displaced in the processes either of the economic or commercial activity that's taking place, or they might be displaced as the Ingonyama Trust sort of makes space for that particular activity in order to conclude that lease. So those are the kind of defining attributes of a third-party lease. And so, as I say, these leases are frequently centered around some kind of commercial purpose, some form of commercial gain. And some of the kind of classic examples that we come across are where these leases are conducted with a third party in the form of a mining company, a development company that's building a shopping center. And frequently what then ends up happening is that these leases bring to head and up against each other customary land rights with the trust kind of presenting itself as owner of the land and therefore able to grant the lease and secure the rental. And often, what has happened is that the customary land rights are, disregarded in the processes of those leases being granted. And so this judgment really speaks to and affirms the strength of those rights that are held under customary law and presents a very strong leg against which people can use to push back against these types of third-party leases. And so, as I said, there are a number of these leases cropping up in various parts of KwaZulu-Natal, and they relate to a range of economic enterprises. From some of the work that our unit has done and from what we've been told, in some cases off the record, there are kind of, sort of classical examples, one of which is a case study that we did in Makasaneni, where a surface lease was granted between a mining company and the Ingonyama Trust, and that meant that people who lived in that community woke up to find prospecting taking place on their land without their consent and without them having played a role in granting the mining company access to their land. There also are third-party leases involved in the activities of Richards Bay Minerals, again, where we've seen a lot of tensions and a lot of violence of late. There as well, the Ingonyama Trust has entered into third-party leases with actors involved in those activities. And likewise, we've seen the surfacing of third-party leases in Somkele, where the Tendele mine has also entered into a lease. And interestingly, in that sense, in that particular case, there is the kind of narrative that the mining company or the mining house will say to the community members, we're not able to actually compensate you because we're already paying a rental amount to the Ingonyama Trust. And so again, it pitches a kind of a tension between what the trust is entitled to and what it claims versus what the people who are directly affected are entitled to and what they are able to claim. And so the key question around these third-party leases is the question around what the processes are that the Ingonyama Trust followed in obtaining consent, whether it obtained consent at all. It's interesting that in the case that we're discussing, the trust actually argued that Ipura does not apply on land that's held by the trust. The court found that that argument didn't hold water, but if the trust is of the view that Ipura does not apply, Ipura being the Interim Protection of Informal Land Rights Act, if it doesn't apply to land that's held by the trust, one can potentially infer that the requirements related to seeking consent before depriving a holder of an informal right haven't actually been met and haven't been followed. And so seemingly, a lot of the mechanisms, the internal mechanisms that the trust is using to source consent, if you will, is to speak only perhaps with traditional councils, to speak to traditional leaders. And of course, it's very clear, both through the two judgments that Aninka spoke about, Maledu and Baleni, but also in the current Ingonyama case as well, that consent cannot be granted by just having spoken to a senior traditional leader or just having spoken to the traditional council. And so there is a very big question about whether or not these third-party leases comply with the consent requirements as they're laid out in Ipura. And so as I sort of wrap, the point I really want to leave with is that I think the judgment opens up a really useful path to call into question these other types of leases, whether those are, the business leases and the leases that are held by churches, creches, within communities and held by members of the community. And the reason why the judgment really kind of opens up a very useful pathway is because of these 2 points that I've tried to surface here. The first being this question of whether or not the leases are concluded in a mechanism, in a way that meets the consent requirements, the type of consent, have people who have had their PTOs converted into lease agreements given genuine and informed consent, and is that a standard that we can say has been met through this process? This judgment certainly surfaces that it wasn't the case as it came to residential leases, and certainly I would assert it probably isn't the case with all business and other leases held for other purposes. And then the second kind of really great leg and really great springboard that the judgment puts on the table is that the leases can be challenged and pushed back against on the basis that they actually facilitate a deprivation of rights and rights that are held in terms of customary law, impura, and the Constitution. And so on those 2 grounds, the judgment opens up scope to really call into question a range of other types of leases that have the potential to severely undermine rights that are held under customary law. Thank you very much.
Madundi, thank you very much. I think that is also very helpful guidance that begins to answer some of the questions that are beginning to pop up in the Q&A. So just to invite everybody, I'm going to speak for the next few minutes, but to invite you to put your questions and comments in the Q&A, and we will feed those into the conversation as we go along. What I'm going to do in the next few minutes is just pose perhaps some of the questions that have arisen for me as I've listened to Aninka and Madundi. And though some of them are new questions maybe, but most of them are really old questions that we've been facing for a long time. Aninka, you spoke in a few places about how the state has ignored judgments. What we know, and I think your analysis has made quite clear, is that court judgments often run up against politics. You've made that very, very clear, I think, in your analysis. And we've seen this over and over again as you've enumerated. And so the question that arises for me, and you don't have to answer all of these questions, you can pick and choose what you answer, as well as some of the questions that are coming in from our audience. I'll feed those in as I go along, as I suggested. So what this raises is this question of, I mean, if politicians, if public leaders can pick and choose what judgments of the courts they react to, what will it take to actually get something, to get systematic change, to get to a point where what is in the Constitution, for example, and what is in all these judgments actually gets implemented. And some political leaders, we also know, come out and very obviously, very clearly say, well, you can run off to court and get your judgments, but we will meet you in the streets. And this is a problem across a whole number of areas. Local government, for example, municipalities, resident associations go to court, get judgments against municipalities, and they simply ignore those judgments. Partly, of course, you mentioned for capacity reasons, that they just don't have the capacities, the capabilities to implement some of these things. But in many cases, it's because there's no political will, as you've said. What do we get? How do we get there? How do we get the political will? If the political will is not going to be there, how can activists, how can people in communities force government to do what is right, to do what these judgments say they should do? I'm also curious here, there's some of the applicants, or rather some of the respondents in this case, which you haven't touched on, included the MEC of Cooperative Development, Cooperative Governance and Traditional Affairs in KwaZulu-Natal, as well as the KwaZulu-Natal House of Traditional Leaders. And I'm especially curious about what has been the position of the House of Traditional Leaders on these matters. How did they respond, in this case? And the last thing, maybe 2 interrelated questions. The very curious thing in the way in which land is talked about, and I'm thinking here in isiZulu, for example, people talk about Izwe lenkosi, the land of the Inkosi. I'm always very curious about what does that mean. I mean, it's been very clearly defined in law, as you've put before us here, what rights mean. But there's an illusion that I think we deal with, we live with, in the way in which language is used, where land is talked about as if it is the property of the Inkosi, it is the property of the Ingonyama. And in fact, I've written about inside, I think it might maybe in my PhD, a speech where I was sitting listening to the previous king, the late king, talking about the harbour in Richards Bay, for example, as Ixwebalami, my harbour. So what does this mean? And I mean, is there something that is encoded in the language when we talk about rights that we need to start thinking differently about, and start thinking about shifting some of the ways in which we use language in indigenous languages, for example, where when we begin to feed in some of this thinking around what rights mean, what law means, what these judgments mean, we begin to popularize some of these things in a way that they begin to change the way in which we use language. Madundi, feel free to respond to some of that if you've got anything to say. And that's the related final question, really, which is how do we begin to popularize some of what is in these judgments? I know LARC does a lot of work running workshops, but that work that LARC does, of course, reaches a small sliver of people. Often people who are activists. How do we popularize this beyond LARC, so that Nolondi, what you're talking about, where people can get up, can challenge the department, for example, can approach the portfolio committee. How do we get there where people actually understand and know what these rights mean to them, so that they can begin to stand up and actually lay claim to these ownership rights that has been enunciated in these judgments? And then Nolundi, you suggest the department, the portfolio committee, and as a last resort, potentially litigation. There's a big question about, and Aninka talked about this, capacity again. If suddenly, we're talking about in KwaZulu-Natal a lot of people in rural areas who might potentially then start flooding the department, flooding the cooperative governance potentially in the province, or even the portfolio committee with requests for interventions. What is the capacity of these state institutions, and what can they cope with? Aninka has alluded to the state not having the capacity to do anything about some of these judgments. In this particular case, is there anything different? Is there anything shifted that would allow the portfolio committee, the department, to deal with these requests if they flood in numbers? And with that, I'm going to just turn to some of the questions that we've had coming in the chat. Mary De Haas was first out of the starting blocks, but I think Nolundi, you've addressed that question, but I'll read it out anyway. What are the implications of this judgment where the trust has given a lease on traditional land for a business? For example, an oil storage or facility or refinery can be established. And I think the crucial part is this element, which is people living on that land do not even know about it and have been told they have to move. In Bembeni, next to Richards Bay Harbour, is the case that Mary cites. There's also a question here from Joe Dowes. What are the implications of the judgment for the other landowner, quote unquote, landowner responsibilities? For example, in terms of rates payments, legislated requirements for invasive alien plant removal, etc. Previously, some of these responsibilities have been seen to be that of the Ingonyama Trust. Although there's even been debate about this. Would that mean that then those responsibilities shift to the people who hold the rights on that land? Would that be individuals that you are talking about, Aninka, are the people to whom these responsibilities shift? Aisha is asking the question, has the Ingonyama Trust been audited by the AGSA, and if so, what have been the findings over the years, particularly when residents were signing leases? And you mentioned that the portfolio committee has tried to ask questions. What has been the extent of those questions? What have been the responses to them? Musa Zama, I'll take two more. Musa says, in terms of those whom their properties were taken or demolished by the chiefs, stating that the ITB Act allows them to do so, can they now use this judgment to file lawsuits against the Amakosi, the Izinduna in some cases, and the Ingonyama Trust Board? And then finally, let's take Emily Kyale's question. What would happen to those who are holding PTOs, RTOs, and those who previously bought parcels of land in rural areas? So let's take your responses. Aninka, we'll start with you, and then we'll come to you, Nolindi. Unmute, please, Aninka, and please keep your questions coming in the Q&A.
Okay. So, in this issue about politics versus law, Mbongiseni, I've been involved with a lot of litigation about land rights over the years, and I must say, this is the first case we've done in KwaZulu-Natal, and the levels of intimidation in KwaZulu-Natal are something else. I mean, we really struggled to get an institutional applicant that was based in the province. Even really well-established churches who themselves have had their age-old, very strong PTOs converted into leases and then been told to restrict their areas of land, were too scared, actually, to be applicants in this case. So you had an extraordinarily brave woman, Mamsazani Ngubani, who tragically died from COVID, and the rural women's movement as an applicant. But we really have got to understand that the applicants, the old women and men who were the applicants in this case, were extraordinarily brave. And I think, what's happening now is that they've proved that you can actually take on the Ingonyama Trust and you can win. And so you're getting many, many people approaching them and approaching LARC about what the implications of the judgment are, whether they can also litigate now to get their rents paid back. I mean, this Nolundi's input is very important because a lot of people didn't understand that if you've got a residential lease, you don't have to do anything. Your money will be repaid to you. You have a right to have that money repaid to you. But if you've got any other kind of lease, then you do have to take steps. So what I'm saying is that I think these judgments do have important implications on the balance of power at the local level. And what is extraordinary is how strongly people believe that they own the land. So, in relation to your question about language and Israel and Nkosi, you've also got in that same language ideas of the land being mine, the land being ours. We did a lot of, we once did a survey of 3,000 women, and when we asked them questions about ownership of land, and we broke it down into what that means in terms of who got access to it, who controls decisions about the fields, we came up with extraordinary answers in which women saw themselves as the primary, the people who had got the land and who it actually belonged to. So I think language is complicated and layered, and just as I could say, I own my house and mean my children and I, or my husband and I, or we and mean many different kinds of we's, I think one can burrow deep into language. But what's really been extraordinary for us is just how strongly people feel that they are the underlying owners, that the Constitution protects them, and that government is selling them out. And so the readiness of people to actually litigate these kinds of matters. Now, litigation can help to stop government and whoever doing bad things, but when you're trying to make government do good things, it's really, really problematic. And I think the time has now come, actually, for litigation in relation to enforcing the rights to Section 25(6). So all of the litigation until now has been trying to stop government from undermining land rights. All of it has been about stopping our post-apartheid government from dispossessing Black people who are structurally vulnerable of their land rights. And it's a terrible shame that that's what my colleagues and I have to spend all our time doing. But I think the time has come for it to shift now and to say the Constitution promises a law to secure tenure rights, and where is that law? And really, that's where the Motlanthe high-level panel report was so interesting, because there you had a range of people as panelists, and what they were most excited about was the idea of a proactive way of recording customary land rights, which isn't just making them into quasi-individualized Western land rights, but trying to capture that essential quality of those rights being inclusive and belonging to the family and the group, as opposed to the individual excluding all others. So, I think there really is an incredible job that could be done in recording customary land rights on their own terms. How we're going to get government to do that really depends on what goes on with state capture. Because what's happening now is land rights have become a resource that is given to elites, and that removes the responsibility from government of having to do the onerous task of actually recording and registering the individual rights that exist in the former homelands for 18 million South Africans. And as long as we've got this nexus between elites and the ruling party, and the incentives to use land and the land reform budget to pay off certain supporters, we're not going to see any kind of real change, except that it has to be a disgrace for our government to be repeatedly sued and to repeatedly lose in cases where it is abrogating the land rights of the poorest and most vulnerable South Africans. And I mean, this judgment is really an extraordinarily strong warning about what custodianship means and would mean writ large in South Africa. And what we've got at the moment is this debate about Section 25, which should be a debate about why has land reform failed, and instead is now a debate about how can we muddy the waters, obfuscate our failures, and find other ways of giving elites control over the property rights of the most vulnerable.
Madundi, over to you, Aninka.
Thanks. Thanks, Mbongiseni, and thank you to everybody for some really great questions. To Mary's question about what happens when people don't actually know about the arrangement and the agreement that's been struck over their land, and they're just being told that they have to move. I think Mary has spent many years working as a violence monitor in KZN, and so she knows well that frequently there is quite a lot of secrecy, quite a lot of disinformation, no information that shrouds, developments and deals where the stakes are quite high. And so unfortunately, this type of situation where the land rights holders, the people who will be most affected, don't actually know that they're potentially going to be dispossessed is quite common. And it is the kind of arrangement, the kind of reality that is made possible by practices of consultation, practices of seeking consent that only focus on leadership structures. And so for the people who live in these communities, one could encourage them to try and source information, but it's also about people who live outside of those communities asking questions. Because when the stakes are that high, the risks for people who are based locally are also quite high. And so, for that community, I think it would be important to also be in solidarity with others who can help focus attention and surface information where it's possible. Aisha asked a question about the Auditor General and the auditing of the books, the Ingonyama Trust books. The Portfolio Committee has received audits, I think with fair regularity for the Ingonyama Trust activities, but those audits have never been clean audits. They've always been qualified in some or other manner, which of course, again, surfaces a question as to what is actually happening in terms of the operations and the financial operations at the Ingonyama Trust offices if they're unable to present clean audits to the Portfolio Committee. There was then, Mbongiseni, your wonderful question about capacity, which is always, kind of goes hand in hand, I suppose, with these court victories. And, I think part of the way in which this particular judgment tries to respond to the capacity point is that one of the kind of remedies that was asked for was a supervisory structural interdict. And so that was part of the order. And that means that the minister has to report back to the court every 3 months on progress that's been made in terms of fulfilling the order. Now, it's not a silver bullet to the capacity constraint point that you make, but at very least it does mean that there is hopefully a mechanism to try and track progress in meeting the order, but it also then hopefully gives the applicants an avenue, which one would hope they wouldn't need to use, but an avenue to return to court and to say, look, in spite of this particular order that was given, the report is showing that there's no progress being made in terms of honouring and fulfilling the order. And then the last question I wanted to just kind of speak to was one that I saw in the question and answer chat, which is this big question about what do you do now if you have a lease and you are sitting at home, you have a lease, what happens now? This is the question that I think we're also really eager to receive direction on. At this point, we haven't come across any kind of directional communication from the department or the Ingonyama Trust itself with regards to processes, for example, for getting or seeking the refund and how exactly that's going to happen. And it of course circles back and is connected to your point about capacity, Mbongiseni. It is no small undertaking to have to refund the holders of residential leases. And while it is an incredibly important judgment, an incredibly important victory, it could well be undercut because of capacity constraints. We could well be sitting here 3 months from now, 6 months from now, with still sort of murky clarity around how exactly this is going to happen in practice. But as I say, the sort of perhaps saving grace is that we do have a basis on which to return to court and say, the minister hasn't made any progress within the stipulated timeframes, and is there some form of redress?
Thank you, Nolundi. I think just to return to the chat and pick up some more questions, I think I'll come to you now. I think the next question follows on. You've answered Zed's question. There's a question that follows on from what you're saying, which asks, has the PTO system been found to be constitutional at all? Is the first prize that returning to the PTO system only as a transition to a better regime yet to be codified? There's also a question, actually before that, it asks, can you confirm that you've emphasized that residential leases are automatically cancelled? Madundi, I think this is for you. Can you confirm that this also applies to leases for arable and grazing land? Emily, celebrating, comment is saying that victory, this is victory for us all. Are we in a position to amplify this to other areas where they can't connect and follow on in these virtual meetings? Viva the spirit of Mamsizan. And then there's just a practical question. Are you going to put this meeting as a webinar online so that it becomes available to other people? Siabu, thank you for your comments. I'll just pick up these 2 comments here. Siabu says legal judgments of this nature inherently have a limited role in effecting systemic change. Part of the problem emanates from the nature of how the court system functions. Secondly, it emanates from the state capacity or lack of political will intersection. We can make three choices: look inward, look outward. Thirdly, the problem emanates from the epistemic dominance of Western paradigms. Feel free to comment on any of that. And Siabu also agrees with Aninka that land rights of all kinds should be made visible in their own terms. Aninka, back to you.
Okay, just to say to Danielle that what the judgment says is that the minister must issue PTOs until she introduces another system to recognize customary land rights. So Section 25(9) of the Constitution says that the minister must introduce a law, Parliament must enact a law to give effect to security of tenure. There is no such law. So what they're saying is, in the meantime, you must issue PTO certificates, but that would be as an interim measure until new law is in place. But what the judgment very clearly shows is that PTOs, ironically, even though they were an apartheid institution, provide far stronger rights that can only be cancelled by the minister and don't require rent than the rights required by the leases. And then Musa asks whether people can use this judgment to file lawsuits against chiefs. And yes, this judgment does set the precedent that the Ingonyama is not the owner of the land, and that any actions that dispossess people of their rights or disturb people's rights without their consent infringe on their property rights. But unfortunately, you would have to bring a new case to do that. But I think there are very, very strong precedents in the judgment that can be built on. I saw that question from Joe about whether this judgment means that people must pay for rates rather than the Ingonyama Trust paying for rates. And basically at this point, the status of the land, as the Constitutional Court has found, is that it's state land. And until there are legal measures that actually record and secure people's rights, this land has to be treated as state land in respect of the enforcement of things like rates, because you can hardly expect people to clear alien vegetation and pay rates when they don't have any enforceable proof of their rights. So until that happens, I think they are protected from that. And just to say, Mbongiseni, you asked about the question of the House of Traditional Leaders and how they responded. And it seems that they and COGTA just decided to abide the judgment. But one thing that I do want to say is that this judgment has gone into far more depth about the nature and the content of customary land rights than most judgments which have just upheld them as constitutional rights. And we think that that's probably because the main author of the judgment, Judge Madundi, is a very proud traditionalist who's written about traditional courts and supports all these traditional institutions, and that has given him obviously a much more detailed knowledge of the nature of customary law rights. And so while some people may have expected that they'd get a less sympathetic judgment from a traditionalist, actually what is so wonderful about this judgment is that he has upheld customary law as a source of rights, as a source of accountability, and as a means of protecting people from arbitrary deprivation, which is so refreshing compared with instances where tradition is used as a kind of blanket to justify dispossession in the name of upholding monarchy or whatever. So, I think we've seen a similar process with the Portfolio Committee, and the most recent Portfolio Committee has been particularly active in trying to get the trust to account for what it's done with the money it gets from leases. It's tried and tried and tried and said, how do these leases benefit people and how does their rent benefit people? And that is also led by, it's led by Nkosi Mandela. And in a way, he has said, we need to, we've got high standards of this institution. It is a it's a traditionalist institution, and as such, it cannot get away with dodging and diving. So I think what's been really wonderful is that we've had traditionalists holding the Ingonyama Trust to account in a way and with a depth of detail and energy that we haven't actually seen in, with people who are more educated in Western kinds of law. And I think that really speaks to, the failure to teach customary law properly in law schools in South Africa.
Thanks, Aninka. Madundi, any comments on any of those questions and comments?
Sure, yeah, I'll just answer Magdalena's two questions very briefly. So the one around whether we're going to make this webinar available more widely, yes, we will. So the recording can be accessed. We'll share that on our social media platforms and on our website. And then Magdalena's other question was around confirming that the judgment applies to arable land and grazing land. So yes, the order is quite clear that the residential lease agreements that were concluded in respect of residential land, arable land, or commonage on trust-held land, and where those leases were concluded with people who are owners under Zulu customary law and who would have been entitled to permissions to occupy, those leases are declared unlawful and invalid. So yes, it does apply to arable and grazing land. Thanks.
Thank you. As we move towards the end of this event, I want to just ask you, both you, Nolundi, I'll start with you, and then Aninka, to just outline for us where your thinking is at in terms of the next steps. What do you want to do? It's been almost a month since this judgment was handed down. And there are questions here, for example, about what do people do now since these leases are getting automatically, now automatically cancelled. Muzi is saying in the chat, he is considering the route of bringing a new case, following on from his question about whether this judgment can be used to bring cases against Amakosi and the ITB. Where are you going with this? I mean, there is, of course, Madundi, as you mentioned, that the minister has to report back to court every 3 months. What are you watching? What are the next steps for you on this?
Thanks, Mungisen. So as I said, part of what we're still curious about are these third-party leases and, what they mean for community members whose customary law rights are undermined through the processes of granting these leases. So that is something around which we still hold much curiosity and are interested in doing work. Then there's also, I think, the question of, how the judgment actually plays out in practice. So for us, it would be, incredibly useful and helpful to hear about people's experiences in trying to either secure new PTOs and to see if they're able to do that, because as Aninka pointed out, the judgment does require that PTOs be issued to people who are entitled to receive those. And then, of course, to kind of watch the space to see what guidance is provided by the department in terms of people's ability to secure those refunds that are entitled to them and to have the leases, invalidated and cancelled. But certainly, I think wanting to make sure that the interim measure that's put in place by the judgment in relation to the issuing of PTOs is really important to see that is playing out in practice, so that people aren't left in a gap with an invalid lease, but then aren't also granted something that can hold the space in the interim. So I think off the top of my head, those would be the two things that we're keeping an eye on. Thank you.
And Aninka, any final comments?
Well, just to say that we heard yesterday that the Ingonyama Trust Board is appealing the judgment, which is quite a disappointment because the minister, thankfully, has said she's going to abide the judgment and she's going to make the system work. And also, we understand that she actually went to KwaZulu-Natal or has communicated with the Trust Board about abiding the judgment. So I think we are going to look at this appeal, and obviously one of the questions is, insofar as the Ingonyama Trust Board is appealing, who gave it the authority to appeal? What processes within the board authorized that appeal? But otherwise, I agree with Madundi that really what we've got to look at is making the implications of the judgment plain for people in KwaZulu-Natal in respect of residential leases and how they can and where they can go and record their names and apply for their refunds. And then, you know, for me, this question of the third-party leases is crucially important because that's where the big bucks are. And that's where people get kicked off their land for these investments. And now we have this wonderful precedent. And hopefully we're going to have braver people in KwaZulu-Natal who've been empowered by this judgment who will come forward with examples, and we can proceed with that litigation too.
Great, thank you both. So let me thank both our speakers for this afternoon. I think Aninka Muzi is one of those people, brave people, who is signaling that he is thinking of taking on the Inkosi. Let me end off by saying, just making 2 points. One is, I think Aninka mentioned Mamsizane Ngubane of the Rural Women's Movement. It would probably please her immensely, wherever she is, that there's been such a progressive judgment as we've heard here this afternoon. So this is to honor Mamsizane for the incredible work that she did and the heavy lifting that she did to get us to where we are, to be having this conversation today. Mamsizane, wherever you are, I'm sure you are smiling down on us. And then I want to end off by just letting you know that next Wednesday at the same time, there's going to be another discussion. I think I'm correct, Nogwanda, that it's next Tuesday at the same time, 4 to 5:30. The next discussion is going to be focusing on the high-level panel that was led by former President Kgalema Motlanthe, and the speakers there will be former President Motlanthe himself, as well as Nolundi Luwaya. Sorry, please correct me, Nogwanda. Next Wednesday, the 14th, I beg your pardon, of July at 4 p.m. is going to be the next event. And the speakers will be former President Kgalema Motlanthe, as well as Zenande Boy from LARC. I beg your pardon, my email is not open in front of me, so I was getting confused about my information. So that brings us to the end of this discussion. Thank you very much, everybody, for joining us. Thank you, colleagues at LARC, for the amazing work that you are doing. And we will see you again at the next event on the 14th of July. Thank you, everybody.